Developing effective labor law and employee contracts for international companies in the European Union. In the dynamic landscape of the European Union, EU, crafting robust labor laws and employee contracts for international companies is a critical task that demands a comprehensive approach. As companies navigate the complexities of the global supply chain, it is essential to consider various aspects to ensure legal compliance, employee satisfaction, and operational efficiency. This video explores the key elements that should be included in labor laws and employee contracts within the EU context and highlights common pitfalls to avoid. Key aspects to consider. 1. Compliance with EU regulations. The foundation of any labor law or contract in the EU must be compliance with the extensive body of EU labor regulations. This includes adherence to directives such as the Working Time Directive, which mandates minimum rest periods and maximum working hours, and the Temporary Agency Work Directive, which ensures equal treatment for temporary workers. Companies must stay updated with these regulations to avoid legal repercussions. 2. Harmonization and local adaptation. For international companies operating in multiple EU countries, harmonizing labor practices across borders is crucial. While maintaining a consistent baseline in terms of employee rights and benefits, companies must also adapt salaries and benefits to align with the individual standards of each market. Each EU country has its own economic conditions, living costs, and labor market dynamics. Conducting thorough market research to set competitive and fair compensation packages that reflect local conditions is essential. This approach not only complies with local legal requirements but also helps in attracting and retaining top talent, ensuring fairness and reducing administrative complexity. 3. Supply chain considerations. In today's interconnected world, the supply chain is a critical aspect of business operations. Labor laws and contracts should address the responsibilities of companies towards workers in their supply chains. This includes ensuring that suppliers adhere to ethical labor practices, providing safe working conditions, and prohibiting child labor and forced labor. Incorporating supply chain accountability clauses in contracts can help maintain the company's reputation and operational integrity. 4. Employee benefits and well-being. Employee well-being should be a central focus. Contracts should outline comprehensive benefits packages that include health insurance, paid leave, and retirement plans. Additionally, considering the growing trend of remote work, contracts should address provisions for home office equipment and allowances, as well as clear guidelines on remote work expectations. 5. Dispute resolution mechanisms. A well-defined dispute resolution mechanism is essential to manage conflicts effectively. Contracts should specify procedures for addressing grievances, mediation, and arbitration. This not only helps in quick resolution of disputes, but also fosters a sense of security and trust among employees. 6. Diversity and inclusion. Promoting diversity and inclusion within the workplace is not only a legal requirement in many EU countries, but also a business imperative. Labor laws and contracts should include anti-discrimination clauses and policies that promote equal opportunities, regardless of gender, race, age, or disability. This helps in building a more harmonious and productive work environment. Developing effective labor laws and employee contracts for international companies within the EU requires a balanced approach that considers compliance, harmonization and local adaptation, supply chain integrity, employee well-being, dispute resolution, and diversity. By addressing these key aspects and avoiding common pitfalls, companies can create a fair, compliant, and productive work environment that supports their international operations and enhances their competitive edge in the global market.